All right, good evening, everyone. Welcome. This is the Town of Somers Zoning Board of Appeals meeting. The date is June 21st, 2022. Denise, would you please take the roll?
Ms. DiPolito,
Present.
Mr. Gio,
Here.
Mr. Hardin,
Here.
Mr. Lansky,
Present.
Mr. Newman,
Here.
Mr. Padavani,
Here.
Chairman Canestra.
Here.
Thank
Thank you,
you.
everyone. Paul, if you could put the flag up, I request everyone that we do the Pledge of Allegiance. I pledge allegiance to the flag
To the
of
flag
the
of
United States of
America,
America and
and
to the republic
for which it stands, one nation,
under
God, indivisible,
with liberty
liberty
and
and justice for all.
Okay, thank you, everyone. Welcome once again. We're going to go right into the first item on the agenda this evening. First item on the agenda is that of Richard Nash. This is an application to renew a special exception use permit for an existing accessory apartment on the second floor of an existing barn to an existing one-family dwelling in an R80 residential district at 5 Two Penny Lane, Katona. Mr. Nash, I believe that you are present with us?
Yes, I am.
Okay, thank you for joining us this evening. Could you briefly describe your application to us?
In what mannerism?
Well, I
I
assume that-
had to apply for a 7-year renewal.
okay. So the apartment is existing. You made application. Is the apartment currently occupied by anyone?
Yes.
Okay. And how many people reside in the apartment?
A woman and a man.
Okay, okay. Let me go to the building department. Tom and Denise, have there been any complaints regarding this apartment? Any issues or concerns that we need to know about?
No,
All right. Tom, I assume you've made an inspection of the apartment and it still complies with the code?
I have, and it's as originally approved.
It is as originally approved. Okay. All right. Thank you. Other questions from board members for the applicant? No?
I'm good.
Okay. I'm going to open it up then to the public hearing. If anybody wishes to speak in regard to this application, anybody online, if you have any comments regarding the application, for those of you online with us, you can simply dial one of the numbers in the white box, put in the Zoom meeting ID number, and you'll come right on with us. And you are free to make any comments you like. This is a public hearing, so we want to hear from any interested members of the public regarding it. So we'll leave this open for about a half a minute or a minute and see if anybody wants to comment in regard to the application.
Okay, Chairman, I don't have anybody at this time.
Okay. Appears that we don't have any public comments in regard to this application. Any further questions from any of the board members? Any discussions we need to have in regard to this application?
Yeah, I come to second thought I do. Tommy, the septic fields, is that a separate from the main house, or they're tied in together? And when was it last pumped out?
The septic pumping receipt is part of the application, and the date on that is 6/10/2022.
Okay, so it does have its own separate fields?
I don't recall. Mr. Nash, can you provide that information to the board? That septic, separate septic system from the main house?
I think I got some of that. I didn't get it all.
Yeah, what the inquiry was is, do you have one set of septic fields for your home and the accessory apartment, or is it a separate set of?
No, it's one set of fields, and when I built my house back in 2006, I overdid the fields with a lot of
Okay,
leakage. It's like a
Okay.
1,250 gallon tank. Okay,
does it have-
and the fields, I don't know what the requirement were for the fields back then, but let's say if it was 1,000 feet, I put in 1,500.
All right, thank
So
you
they-
regarding
the
that
an-
now.
yeah.
Does it have two separate septic tanks or just one?
No, it's got one.
Thank you. And there's a Tommy, again, with your inspections, in case there is, God forbid, a fire, is there two ways to get out of the second floor?
Yes,
And smoke detectors? And,
carbon monoxide, smoke, yes.
all right, thank you.
Any further questions of the applicant? Any other discussion points? Nope. Okay, Mr. Nash, is there anything further you'd like to say in regard to this application before we vote?
No, it was approved going way back when I originally built it. Okay, and nothing has changed. It's been that way since 2006.
Okay. And all these approvals are 7 years if they're granted, and then you have to come before us again, so, okay. All right, I think it's time to vote. Can we have a motion as to the type of action?
I'll make a motion type 2.
Second. Ms. Polito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Mr. Padavani,
Aye.
Chairman Canestra.
Aye.
Thank you.
Can we have a motion whether we're going to grant or deny the 7-year application in regard to Mr. Nash's request?
I'll make a motion to grant the application for a special exception use permit for another 7 years.
I'll second it.
Ms. Polito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Mr. Padavani,
Aye.
Chairman Canestra.
Aye.
Thank you.
Congratulations, sir. Your application has been granted.
Thank you, board. I really appreciate it. Everybody
you
have
have
a
any-
nice week. My best to your families.
Thank you.
Thank you.
Same to you. Okay, so we're going to go to the second item on the agenda this evening. This is the application of Martin and Megan Richardson. This is an application for a front yard setback variance for a front porch addition of an existing one-family dwelling in an R80 residential district at 32 Francis Drive, Katona. Who will be speaking for the applicant this evening?
I am here representing the applicants. This is Michael Picarello, MAP Architects.
Okay, thank you. So, sir, could you briefly describe the application before us?
Sure. Richardsons own a single-family wood frame dwelling on Francis Drive. It's a single-story structure. The concept is, as their family has grown, they want to also grow their home so they can stay in their keep the kids in the schools, keep them in their community they enjoy and their street that they like. So in order to do that, they need a larger home. The existing house, the face of the existing house is existing non-conforming, where they need 40-foot front yard setbacks. They only have 38.4 currently. And the project is to go up on a second floor and to create a front porch. Both the front edge of the second floor and that front porch will require a zoning variance. We're proposing 30.4 feet, where 40 is required. So we're looking for a front yard variance. The thought is we're going to be that the house will be an improvement over the existing house, as well as allow the Richardsons to stay in their home and grow their family and continue to be part of the community. So that is a thought. And also between the house, aesthetically being an improvement, it's not any different than the other characters in the neighborhood. So it's not a detriment to the neighborhood. It's not an unusual size of a house. We're not overbuilding. We're just going straight up. So again, we're not overbuilding. We're very sensitive to the neighborhood as well. So that's the summation.
Okay. Because one of the questions I had when I first looked at this application, I was a little confused because I saw it was an application for a front yard setback for a porch, but then the addition on the second floor. So I think you explained this is a one-story house. You're putting a second story on it. So therefore the second story is, basically going to also need a variance.
Correct. Yeah. So the second floor will also be non-conforming, and then the porch pushes even further. So yes, but we think the porch is an added value. It's a front porch. It doesn't really, detract from anyone's views in the neighborhood. And I think aesthetically, I think the house is going to look fantastic. So I think it'll be a plus to the neighborhood.
Members of the board have a question for the applicant?
When I look at an image of this house here on Google, it looks like it has a sort of a U-shaped driveway in addition to the driveway to the garage.
Yes,
Um,
that's existing.
right. And so this front porch, that driveway is not going to move. It's going to stay right where it is. The porch will just come closer to it, or?
Correct. Exactly. Yeah. There's actually an existing walk that goes along the front of the house, which is a little sidewalk that will be removed for this porch. So it's and then obviously the existing drive will stay how it is currently.
How many bedrooms are being added to the home?
We are not increasing the bedroom count. We're actually taking the bedrooms that are currently, we're not adding any bedrooms. The current bedroom count is remaining the same.
Okay, because of course there's septic issues and Board of Health issues if you add bedrooms.
Correct. Yeah, we're going to make sure that we comply with everything that the building department requires, but because we're putting all of the bedrooms upstairs now, and moving them from the first floor to the second floor, we don't foresee any health department issues. And I'll work with Tom and to make sure that's the case.
All right.
So the second floor, the area above the porch, right, which is what requires the variance, there'll be living space above the porch.
But no, if you look at the drawings, it's a true front porch. There's a couple little dormers that bump out on top of the porch for about 2 feet. So
Okay.
no, we're not building on top of the porch, only 2 little dormers. So you can see it in actually the site plan. We're showing those dormers in the site plan, as well as obviously in the drawings themselves.
So the living space would be 38 feet, just like the existing living space from the.
No, because the dormers do come out over the porch a little bit. So they will be about approximately 2 more feet in. The front edge of the porch is 30.4 feet. The existing is 38.4. So again, the second floor living space will be, encroaching deeper than the 38.4, approximately 36.4.
Yeah. Tom, if you look on the elevations on A200, that most clearly shows the building, yeah, and the bump out above the porch.
Yep, got it.
And aesthetically, the addition is going to match the existing house.
The existing house is stucco, and this is going to be siding.
Are you going to side the whole house?
Correct.
Reside the whole house to match?
Correct.
Right.
the whole, it's essentially from their perspective, it's going to look like, aesthetically, it'll look like a brand new house to them.
Right.
Yeah, again, the idea is to improve not just improve the function of the house and their living space, but to also improve the aesthetics of the house. So.
Any additional questions for the applicant at this time? Okay, I think we should maybe take this out to the public and see if there's any comments or questions from the public. Once again, anybody on our Zoom meeting right now can speak in regard to this application. Anybody from the public who's out there who would like to speak, please call into one of the numbers in the white box, put in the Zoom meeting ID number, and we can then hear you. I will also, while we're waiting here, make mention that the building department did receive 2 emails today regarding this application. They both were unable to attend tonight. One is from a Mary Beth and Ken Murphy at 36 Francis Drive. They addressed the email to the board. They say, I'm unable to attend tomorrow evening's meeting and wanted to express my support for the above noted application. Improvements to 32 Francis Drive will enhance the neighborhood and add a beautiful addition to our street. I look forward to the improvement to our streetscape that will benefit all who live in Billings Estates. Thank you for your consideration and commitment to our town. That's from Mary Beth and Ken Murphy. We also received a second email, also addressed to the board. This is from a Mary Riley at 39 Francis Drive. She said that I am unable to attend tonight's meeting, but support Marty and Megan Richardson in regard to their application for an area variance. Improvements to their home will enhance our neighborhood and make a wonderful addition to our street. And that's from Mary Riley. So I'll just make mention of those 2 emails. Paul, do we have anybody else trying to come on?
No, we do not.
Okay, so we're going to go back to the regular meeting. Okay, anybody on the call wishes to speak in regard to this application? No. Any further questions or comments from the board at this point in time? Let me ask board members, do you think the variance is extensive here? I mean, it's pre-existing, 40 is required. We've got 30.4 feet.
I think that, as a percentage, you might at first glance consider that to be, I don't know, you'd say significant, but it's not small. But when you look at the house, I mean, certainly the drawings look like it's going to make it a much nicer aesthetically. I completely agree with that. But if for those that haven't looked at this on a Google image, there is this U-shaped driveway that runs in front of the house. So you can pull in one side and pull out the other. And it sort of sets a boundary for sort of the front of the house. And if that addition is not extending beyond that, I don't really think it changes the look and feel that much from the street. So given that, I think it looks like a nice house, and I think it's would be a reasonable addition.
Yeah, I visited the house. I feel the same way, without a doubt. It would be great for that neighborhood.
Yeah, and it seems that the neighbors are certainly liking this renovation. So, and this is also a 2-acre piece of property too. So it's not like this addition is overwhelming anything on the lot. So
I think the addition is also comparable to other houses in the neighborhood, and it's a non-conforming property, so this is not something self-created, the need for the variance, and that minimizes the ask in size.
Any further comments from board members? Does the applicant have anything additional that you'd like to say before we vote on this matter?
Not at this time, no.
Okay, I think we're prepared to vote. Can we have a motion as to the type of action?
Bill, you're on mute.
I move type 2.
Second.
Denise, you're on mute.
I'm sorry.
That's
Ms.
okay.
DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Mr. Padavani,
Aye.
Chairman Canestra.
Aye.
Thank you.
Can we have a motion as to whether we're going to grant or deny the variances? Keep in mind, there's two variants here as there's two issues as I see it. There's the front porch and then there's the second floor addition. So both would have to be considered in any motion that we make. Can I have a motion from someone?
I'll make a motion to grant the application for the two variances as submitted on the drawings to the board.
Second.
Ms. DiPolito,
Aye.
Mr. Gio,
Aye.
Mr. Hardin,
Aye.
Mr. Lansky,
Aye.
Mr. Newman,
Aye.
Mr. Padavani,
Aye.
Chairman Canestra.
Aye.
Thank you.
Congratulations, Mr. and Mrs. Richardson. Your application has been granted. Good luck.
Thank you
Thank
very much.
you.
Appreciate it, guys.
Best
Thank
of
you.
luck.
Thank you.
Yep. Okay, so we're going to go to the third item on the agenda this evening. This is the application of Victor and Deborah Wu. This is an application for a side yard setback variance for an existing in-ground pool of an existing one-family dwelling in an R80 residential district at 8 Silver Springs Court, Katona. Is there someone here to represent the applicant?
Yes, good evening. My name is Dan Toda. I represent Mr. and Mrs. Wu. I'm joined tonight by Victor Wu. Good evening.
Okay, good evening, sir.
Good evening.
I think the first, before we get into this application, I think the first issue we have here is to make a decision the board as to whether this application is properly before us. Let me go to the applicant. Sir, this is an application, I guess, from my understanding, from a decision of the building department that there was a violation. Is that, and that I think the applicant was first informed of this violation, I think back in December of 2021.
Yes, there are a number of other issues and extenuating circumstances in this case. We did have this discussion with the zoning secretary prior to the meeting. If it would be beneficial, I'm happy to take you through that background.
Okay, yeah, if you could just explain to us, when the violation occurred, when your client learned of it, when you made application to the zoning board. I'd like to hear kind of the.
All right, let me see if I can give you an overall relatively short summary of the situation. So the facts that are relevant to this case date back to 2007. At this point,
Sir, excuse me
sorry,
one
yeah.
second. Before we get into the facts of the application, I think this board has to determine, is this matter properly before us? So what I would like to hear is first just the timeline of what occurred when your client learned, and then we can kind of go into the detail of the facts. We've got to do one thing at a time first.
sure, and I'm trying to give you that. I believe it is all relevant, but if you'd like me to skip ahead to 2020 or 2019, when this particular improvement first came to fruition, the matter of the violation was first issued, I believe it was in November. But that violation was predicated on the underlying set of facts that remains in dispute. So in terms of the procedure, we believe that there's been no deprivation of right at this point. So we could potentially withdraw the application without prejudice and bring it back to the board once there's a determination as to the violation or the certificate of occupancy. But it seems pretty wasteful and needless given the inequities that would result. So we believe that the board has general discretion, both statutorily and as a function of case law. I understand that the objection was raised by opposing counsel for the neighbor. Again, pretty broad context of the circumstances involving this boundary line. And I believe at this point, we may not have an objection from the neighbor, given the settlement discussions that have evolved all the way up to this morning. But in terms of the board having any authority to hear this case from a procedural or jurisdictional standpoint, we believe that there is case law that supports the application. We believe that although the application was predicated on a violation, there's still an open proceeding in the local court. There's not been a final determination as to whether that CO should be issued or should be revoked. My understanding is that there's been no revocation of the existing CO. So it appears, at least to me, that that's more of a formality than it should be a controlling issue that prevents the board from hearing the case. And I can certainly get into the authority in a little bit more detail if you like, but it again involves the general background that commenced back in 2007 and has evolved over the last 12 to 15 years.
Okay. Maybe what I'd like to do is, Mr. Singleton, I believe that you are here representing the neighbor.
Correct.
Yeah. Could you give me, I'd like to hear your opinion on whether this is a timely application before us.
Okay, well, as your board knows, I've already submitted my my position in writing, and that your board's without authority to entertain the application. I will say this, there's extensive damage occurring to my client's property, which I'm sure they would like to speak to, primarily water damage. And we are and have always been amenable to trying to work with the neighbors to resolve the issue, but it has not come to fruition yet. And the overriding concern right now is that between the damage to the garage, the damage to the driveway, the trees falling down or leaning over, the erosion problem from the water coming from up the hill, that is paramount to be resolved in our estimation before my clients would entertain anything of the sort of not objecting to the application. That my clients are aware of the situation that the Woos are in, whether it was intentionally self-created or unintentionally self-created. It is a situation that they're not trying to cause financial harm to the Woos, but this is pretty blatant encroachment, and my clients don't even have access to their own property. And so we're trying to work it out with the neighbor, but as far as I'm concerned, they're statutorily barred from proceeding with this application.
Okay, and that's really what I want to hear your opinion on. So you believe that the 60-day requirement has not been met and that the application is not properly before us. Based on your papers that you said, I've read everything you've sent us, and that's your position in regard to this matter.
And as far as the proceeding in justice court, not that that's really our issue per se, the prosecution of that case, the way the statute works is you must appeal to the zoning board to get that stay of the prosecution in the justice court. By not applying to your zoning board within a timely fashion, the prosecutor's left with no alternative but to prosecute the case. There can be no stay of the proceedings, and there can be no entertaining of the application by your board. The only thing that can occur is, and you can't simply reapply for a C of O, have it denied and reappeal. There has to be a change relative to the application so as to warrant the consideration by your board of a new application.
Okay, all right, thank you.
Thank you.
May I respond to that?
Yeah, yes.
Okay, if we're talking about procedure, then I can keep it isolated to that because I believe what Mr. Singleton alluded to involves some of the substance of the proceeding, and we can certainly get to that in due course. But the one case that was cited in Mr. Singleton's letter does not capture the full body of case law, which would be relevant to that determination. He cited the Palm case. That case stood for proposition of detrimental reliance over a 10-year period. And this matter can be distinguished from that case. The case that controls is the Ponza case from 1964. It's controlling. In that case, they determined that the board is permitted to hear beyond the statutory period if extenuating circumstances exist. And there were objections during a reasonable time, which in this case there were. We can deviate from the strict interpretation of that statute. There's a duty to construe statutes reasonably so as not to deprive citizens of the important rights that they have, especially where the underlying facts in the case are somewhat open to interpretation, which in this case they are. There's another case, the Panetti case, which is consistent with that ruling. It was argued by Mr. Singleton in Mount Kisco, I believe, as a result of an application where the board needed to authority to make a determination, provided that their rulings weren't arbitrary, capricious, and irrational. So I believe that the underlying facts here support those propositions and give the board the authority that they need to hear this case. And if we can get over that threshold issue, we can get into some of the facts that developed over the course of the last 15 years, which further justify the deviation from that strict interpretation. Aside from that, we are here because the discussions with the town prosecutor and the building inspector to date have contemplated this application. And the entire reason why it wasn't commenced earlier was because we were involved in active settlement discussions with the neighbors to try and bring the board an application on consent. And up until this morning, I had assurances from Mr. Singleton that there would be no objection to our proceeding, provided that, and I don't want to speak for him, but my understanding of that conversation was that he would not object, provided that we were willing to reimburse his clients for the expenses, which we agreed to, that we would restore any types of drainage systems to their pre-existing condition, which we agreed to, and we defer to the town engineer to make a determination as to what that drainage system should be. And this should also be taken into consideration. The original complaint that the neighbors filed was on September 2nd of 2021. You may recall that on September 21st of 2021, we had Hurricane Ida and the entire Westchester area was declared a disaster zone. So I think it's important to understand this in context. I'm sorry, September 1st. And I think it's important to understand this in context because this application should be very narrow and it should not be a forum to litigate a boundary line dispute or any other facts that could potentially be heard in a proper venue that had jurisdiction to make an overall determination.
So Mr. Toto, what I'm hearing from you is that you think you are close to an agreement with the neighbor, and maybe I'm even hearing from Mr. Singleton a willingness to. I mean, are the two parties close to getting this resolved?
My understanding is that there's a resolution in place, but for the timetable of reducing an understanding to an enforceable settlement agreement. I was on the phone with Mr. Singleton on Friday. I was on the phone with Mr. Singleton this morning. We have a written framework for settlement that was exchanged between the parties. The holdup up until this point is we did not want to be in a catch-22 situation where we were serving two masters. We agreed to every item that the neighbor had requested of us, including restoring the fence and the encroachments back to the boundary line. What we asked for in return was that we did not finalize the exchange of money until the ZBA granted this application, because everything is predicated on this specific application. It avoids Supreme Court litigation that involves the town, the contractors, the neighbor. If this application is not granted, we are left with no alternative but to A, remove a pool that will cost several $100,000s to remove and restore to a different location, or explore a claim in adverse possession because these improvements in part have existence since 2007. So this application is the linchpin that everything relies on in order to fall into place.
Mr. Singleton, do you have any comments?
I have a comment. First of all, as your board may be aware, a case from 1964, the Ponzi case, whatever it was, is of no bearing. The law was changed relative to variances and procedures for the Zoning Board of Appeals in 1991. So any cases citing an old standard of review are irrelevant. The statute specifically states that all appeals shall, it's mandatory, take place within 60 days. I will say this. I have been discussing with Mr. Toda the possibility of resolving this situation. I did identify the fact that your board is charged with the determination as to whether or not to proceed. We do not have an objection to working with Mr. Toda and his clients. As a matter of fact, we've been trying to work with them for over a year in this regard, with very little response from the Woos. Very, very little cooperation from the Woos. So I think that's a little disingenuous to suggest that everything's been working out. It's been right. The application was not made on notice to us, except for the statutory notice to the neighbors. It was not done with any prior, notification to us, and that's why we submitted the letter of objection. We do not have a problem working it out with the neighbor, but that does not give us the ability to tell your board that you must accept an application that's untimely. That's within your board's discretion. As far as working things out with the neighbors, I don't want to have anything where there is not a resolution as to the water damage and drainage issues that are occurring by virtue of them disconnecting the drain that has long existed and long worked for these two properties. The encroachment, you know what, it's really not even for your board to get into the issue of adverse possession. I think it's a red herring. The question is whether or not your board wants to entertain the application or whether you can entertain the application. But be clear, the Stancius have been very, very reasonable people. They are willing to work things out as far as resolving the issues. They're not trying to create financial hardship for the Woos, but that does not mean that they have some sort of a grant from the governor of the state of New York to waive the limitations period.
What statute are you referring to for the limitations period?
267A of the town law and 7-712A of the village law. That was the state completely revamped the statutory criteria for the processing of variances for towns and village law and city law.
And is there any prejudice that your client has experienced by the delay?
Well, frankly, I don't think so, other than the damage that they continue to incur.
Okay, and you're aware that some of the statutes have been extended due to COVID.
There's no extension of this provision. There's nothing in the executive law or executive order from the governor that extends this. To me, that's simply a red herring. I think you're.
I'm not saying there's one that specifically extends 267A, but I am saying that the courts have extended a lot of the deadlines throughout COVID. Right. And they often look, when deadlines are missed, at the prejudice to the parties.
Right. And if you look at my memo and it speaks to the cases, what it says is, not that I like that it says this, but it says that your board is without authority to extend the 60-day period. It's not a question of whether or not I want you to, don't want you to. would be prejudiced by you doing, has nothing to do with that. I just don't think that you have the authority. I think what really needs to happen is that a modified application needs to be submitted to the building inspector. I think that it needs to be denied, and then your board needs to rehear it. And hopefully at that point in time, there would be a plan to provide for the drainage that's been disturbed and to restore the property lines to where they need to be. And right now, I don't want to get into the substance of it, but right now, their improvements are not only on the property line, they're well over the property line. And they're not 12-year, 15-year, 17-year existing things. They're brand new encroachments. We've tried to do this, and if you read my correspondence from over a year ago, you will see we have tried to do this in an amicable fashion with the various counsel for the WUs, and it was met without cooperation.
Okay.
So I don't have any ill will towards Mr. Toda. He's been very, I don't know what the word is, cooperative. It's not the right word, but he's certainly been responsive, and he's certainly been, in a collaborative effort. But the fact of the matter is, this is nothing new. We've been trying to resolve this for well over a year, and they won't even allow my clients on their own property. We can't even get into, it's fenced off. We can't even get onto my client's own property. And, we're trying not to go out there with bulldozers and knock down the fences and everything else, which I believe is within my client's right. It's just, it's a very bad situation.
Yeah, Mr. Singleton, I think I'd like to, Mr. Toda, I think I'd like to go to the other board members and get some discussion amongst the board going right now.
May I add to that before you do, Mr. Chairman?
Okay, very quickly though, because I really want to hear what the board members have to say.
Yeah, just that the proposition seems incongruous to me. On one hand, we're here because we're trying to get this variance through, which will ultimately resolve the matter in its entirety. So if we withdraw the application at this point because there's some issue with procedure, we ultimately get to the same point, but we create more waste, more expenses, and it's a prolonged resolution for all parties. If we withdraw the application and ask the building department to make a determination as to whether they're going to revoke the existing CO, or if we present some change in application, ultimately all we're doing is kicking this can further down the sidewalk when we have an opportunity tonight to get this resolved, ultimately put the neighbors where they want to be, start commencing work to restore the sight line that exists on the neighbor survey, and we get one step closer to being done. So I just don't see the need to delay this any further when we have a means of resolving it more immediately.
I think this board, though, has to make the determination based on the law whether this matter is properly before us, if you've exceeded the 60-day time frame. So I think I believe
that you don't have the discretion to deviate from that strict interpretation.
Well, that would be the decision I think we first have to make before we get into the merits or the nitty-gritty of the application. So I'd like to hear from other board members at this point in time.
And just one question, if I may, Mr. Singleton, you acknowledge that there has not been a substantial detriment to your client. And being that it seems we likely will be in this place in a couple of months from now if the 60-day requirement is not found to be within the discretion of the board to hear tonight, are you willing to waive that to go forward, or what is your position on waiving?
I appreciate the question. One, let me clarify. My client is experiencing detriment. Their trees are falling over right now. The driveway's heaving. There's cracks in the garage. There's issues. I don't want to overstate them. I don't want to understate them. But it's not a question of my client being able to waive it. I represent boards like yours on a frequent basis. It's a question of whether or not you have the jurisdiction to. We have no ability, even if the Stancias were ready, willing, and able, they don't have the ability to waive this requirement. So the question really comes to your board, and it's not for me to determine, it's for you to determine whether your board has, just as the chairman said, does your board have jurisdiction to hear this application? That's what it comes down to, by not meeting the statutory deadline. And is there a way to revive the application or to amend the application so that it can be revived? And the answer to that question is, I believe the answer is yes. You can't just submit the new application, get it denied, and get back before the ZBA. You have to amend the application somewhat so that it is different relief that is being sought from your board. So the short answer to your question is, whether my client is willing to waive or not is irrelevant to the question of whether or not your board currently has jurisdiction. And then you put yourself in the position, you put your board in the position, whether the stance use challenge or whether some other neighbor challenges or some environmental group challenges, it doesn't really matter. Whoever challenges, you're not on good footing for purposes of defending your position in Article 78.
I understand that. I disagree. I believe that parties can always consent otherwise. Your stance appears to not be that, so we will decide jurisdiction separately.
Mr. Toda, what was the reasoning that you're stating that this is so many days past the 60 days?
Well, like I said, the issue is that the violations were issued based on a position that the town has taken, that we have no rights to the area where this encroachment exists. A determination of those rights has to be first made before a violation could ultimately be adjudicated. And we are not at that point yet. There's been no revocation of a CO. And there's been no final determination with respect to these violations. They're issued, the town is protected, there's no detrimental reliance, which is the key factor in that Palm case. And in order to ultimately have a deprivation of rights, which would give us a platform to appeal, we would need to finalize and adjudicate those matters to completion, right? And that can't be done in local court, because although they have the authority to determine the violation, it's only the Supreme Court that can make a determination as to whether or not we have rights to that property. We are looking to avoid all of that. We are looking to mitigate damages, but we cannot do those things without this grant of variance. So procedurally, yes, I understand what Mr. Singleton is arguing. I believe that there are more issues with the letter, but we're not talking about the substance. We're just talking about the procedure and the jurisdictional issues at this point. And I believe regardless of what he has just presented, I agree with Mr. DiPolito that we can consent. You can move forward. There's only one neighbor that's affected by this application, and they are present for this hearing. And we could ultimately avoid creating a bigger problem and more damages. I mean, our position at this point is we want to restore the fence to the boundary line depicted on the neighboring survey. We want to work with the town engineer to restore the drainage systems. We've committed to everything the neighbor has asked us to do. We initially presented this back in November. We offered to purchase the property. We offered to purchase an easement. We offered to lessen the impacted area. And all of those options were declined. So rather than make this any worse than it already is and engage in this protracted litigation, we conceded to all of the demands, provided that the town oversaw the process with respect to, I think, what the main issue is, and that drainage. So we're in a position to get started on this right away. We're deferring to the town and we're ready to move forward. So I believe if we have an opportunity to capitalize on a settlement, we should take it. I think it's in everyone's best interests. If Mr. Singleton is not objecting, then I believe that the board has sufficient discretion with the other body of case law that I cited, where they could be comfortable in a determination and we can ultimately resolve this matter.
I mean, what is wrong with, you know, the parties coming to a resolution of this matter, then coming back before us after the fact? Just because let's say we were to proceed, and I don't want to really do a lot of hypotheticals here. We would be granting a variance and we would have to decide, what kind of screening. I mean, there's so many issues here.
I think you just touched on it. I think you just said it, right? The whole reason why this application has been delayed is precisely what you just said. We did not want to present this application with any opposition. We wanted to present it as a nice package with a bow on it so everyone would be comfortable. And we were only, in my estimation, we were only able to get to that point this past Friday. And Mr. Singleton and I spoke. We said we have an agreement in concept. And again, I don't want to speak for him in this regard, but my understanding is that we do have an accord between the neighbors. And there's no reason but for the timetable that's not an that hasn't been reduced to an enforceable writing. But regardless as to whether there's an enforceable settlement agreement in place, if we have the parties on this call, and we do, there should be no reason why we can't move forward with this application with the approval and impose conditions on that approval that speak to the items that Mr. Singleton just raised, like the expense reimbursement, like the restoration of the encroaching fence and underground mechanical and utility systems to the property line that's depicted on their survey. 2, defer to the town engineer for a determination as to what constitutes reasonable drainage systems. The drainage system that we're talking about here dates back to not only the initial development of the project, but all of the plans that were overseen and approved by the town back in 2007. We're not even talking about water that's draining from our property onto theirs. We're talking about hooking up a drainage system from their property and having their water divert into our drainage system. And we're comfortable permitting that as well. And we have complete confidence in the town and the engineer to oversee this process to make sure that the parties are doing what they're supposed to do in accordance with the local law. So, as I said, we have an opportunity now to move forward. I believe it is discretionary. We have the parties on the call. We have the terms of the settlement flushed out to the point where we can speak to them now. And there's no reason why we can't include those items as conditions on the granting of this application.
Yeah,
I think it's
just real quick here. My concern here is though whether we have proper jurisdiction in regard to this matter. We're beyond the 60 days, and there is my concern. So before we get into all the details here, I just don't know that we have jurisdiction to properly hear this matter. I mean, this board did have an executive session with town council, who did give us some advice in regard to this matter. We can take it or leave it. But they did, he did give us his opinion in regard to the matter, and that seems to be a significant issue.
Victor, I struggle with the town prosecutor giving this board advice on someone they're prosecuting.
It's a statute, Clark. It's a straight up statute.
No, I don't disagree with the statute. I did just take a minute and look it up. I do disagree with a prosecutor advising the board. That can be an issue. But that said, I see the 60 days. I know that many statutes have been based on COVID been extended to some extent. This seems to be too long. I don't understand why, Mr. Toto, why you didn't bring a Yellowstone or come to the board earlier. That doesn't make sense to me. I am a little bit stuck, as I think a lot of the board is stuck, that there is a jurisdictional issue. And I hear the argument that the practical thing is nobody wants to just throw money down the drain and fight when they can resolve it and pay for pipe rather than lawyers. And this could be a forum to resolve this matter versus the time in the courts. But, I'm without hearing that there was something that truly delayed you, or there was some type of representation by the town that you or somebody else that you had, they were going to give you additional time, I would struggle to get there.
I can speak to that. This was not done under the radar. This was done in conjunction with constant communications between our office and the town prosecutor. And I don't know if the zoning secretary would like to add to this, but we had a number of calls and meetings where this issue was brought up. And we were under the impression that this is what both the town and the board wanted us to do.
When you say the board, what board are you talking about? The zoning board?
These are communications that we had directly with the building inspector and the zoning secretary in terms of how and when to present this application. And again, and I'll reiterate this because it's an important point. The only reason this application has been delayed was because we wanted to bring it on consent. And we did not want to have any opposition, both procedurally and substantively, so we could ultimately move forward with a global resolution. That's exactly why.
Did you realize?
But now
that
you're not bringing it with consent.
As of this morning, I thought we were.
No.
But now you're not.
I think it's time for me to weigh in a little bit. What I've told Mr. Toda, well, first of all, my clients are now being subjected to literally a pool on their property line because of mistakes made by the applicant, by the applicant's contractors, and frankly, by the town. We are trying to work out something that is very, very impactful for my client. As far as things being put on the table that my client refused or demands that they had, I think that's not exactly accurate. My client does not want money. My client is not here to sell an easement or do a lot line adjustment or anything else. They have been very clear with me. They don't want money. They want their property. And to that end, we have been cooperative. Mr. Toda's involvement and this whole process of even a dialogue going on here, that all started after this thing was already time barred. We are willing to do this the right way. I think what your board should have before you, and this is my professional opinion, it doesn't necessarily have to be the board's position or the WU's position. I think that what should happen is if an application is going to be made, it should be made with an engineering plan showing what's going to be done with the drainage. It should be reviewed by your town engineer, and you should have some feedback before you're acting on it. And in that regard, I think coming back with a new application is the best way to insulate yourself from being overturned on appeal in Article 78 by anybody. And as far as Mr. Lansky's concern about the prosecutor giving advice to the zoning board, I think that your board should take advice from whatever attorney you feel comfortable with. The town attorney, the prosecutor, the zoning board counsel, outside counsel. But I can tell you, this shall be brought within 60 days is not subject to interpretation. It's mandatory. There are hundreds of cases that throw out these actions where the board reviews something that's time barred. It's as simple as that.
Mr. Singleton?
Yeah.
If this application, instead of being for a review of the determination of the building inspector, was simply for a variance.
Yep.
Would you have an issue with it?
Yes, it would be time barred. You seek an application, if you seek a permit and it's denied, you have a period of time, 60 days, within which to seek a variance. If you seek an application that's denied, and you want to seek an interpretation from the Zoning Board of Appeals, you have 60 days to do that. If you're charged with a violation and you wish to appeal that and stay the proceeding before the Justice Court, you have 60 days to do that. None of that was done in any of these circumstances.
But Mr. Singleton, by doing what you're doing, you're trying to make, and I can see this, you're trying to make this go backwards and put yourself in a worse situation than you were in before. I don't know why you seem to be arguing that we're not eligible because of the 60 days. All right, let's assume that's true. Mm-hmm. Where are you?
Where am I?
After if we decide that we can't adjudicate this at all,
right,
then it goes back to you, I guess. Where would you be? You want to go back arguing with this other guy?
No, I've been through enough attorneys for the woos already. What I would like is what I did over a year ago. I would like to have resolved this without implicating the town. It was only when we didn't get any responses from the woos to our correspondence that we determined that we had to start sending notices to the building inspector. In that regard, where am I? My clients are in a terrible position because one, the neighbors have built something on the property line and into my client's property, which needs to be removed. The town didn't pick it up. It was clearly shown on their plans. I mean, there was setbacks on their property demarcated. The pool now is to the other side of that, those setbacks. This is a terrible situation for my client, but if it's going to be resolved, it should be resolved in a professional and orderly fashion. As far as I'm concerned, it's already been well over a year. And as far as the damage to my client, the applicant is welcome to bring a modified application and see what happens with the building inspector and see what happens with your board in the future. Or alternatively, if they can't bring it, they have to remove the pool, which quite frankly isn't, really shouldn't be out of the realm of consideration. My clients do not want that to happen. They are not out there trying to force the removal of the pool. We have said that from day one in our first correspondence with them. And I provided you with some of those correspondence. It has been a stone wall on their side, literally and figuratively. So I think it's highly disingenuous to make it sound like we're prolonging the process. What, we're prolonging the process so that there's a pool on my client's property line? We're prolonging a process where the neighbor has put a fence excluding my clients from accessing portion of their property as their trees are falling down and their driveways heaving? Yeah, it's not a good situation. But I do believe that if a board is going to act, it should act in a fashion which is compliant with the law. And how does that benefit me? I'd rather see an engineering plan incorporated into this. I'd like to see everything laid out. I have had discussions with Mr. Toda, but they've been discussions. They've been in theory. There's no settlement that has been reduced to writing. And that is something that I think, quite frankly, given the people that we're dealing with, I think that's necessary. My client has had to hire a couple different surveying companies. They've engaged my services. I've had to go up to the site and review them. They've had to deal with water damage all over the place. And they get bupkis from the woos, quite frankly. Excuse my colloquialism. This is being turned around a little bit. My clients have been seeking resolution of this thing for well over a year. And now with a pool over the property line or improvements over the property line, we're being told, why do you want to hold it up? It's nothing to do with holding it up. It has to do with making sure that your board has proper jurisdiction to hear the case. And that there's a proper engineering plan in place. The water is devastating, what's going on with the water. I mean, they literally just disconnected the pipes and then changed the contour of the land so that, and blocked it off.
Hey, Vic, just a thought, Vic. I think I've heard enough from the attorneys. Is there anybody from the public that needs to speak?
Sorry.
No offense, guys. I get it. I get it.
Yeah, we're kind of going over the same material. I certainly.
Right, you
agree.
are.
Yeah, I'm not even sure. Is this a matter that should even go out to the public? Whether we're going to take this case or not?
Yeah, no, I don't. I mean, I don't know if it needs to, if it needs to be opened or not. Denise is shaking her head no. Okay.
Yeah, I don't think this is a matter. Yeah, this is a matter that the board has to decide whether it's properly before us or not.
Right. I think we should decide that before we go any further.
Yeah, I mean, to get into the minutia, we got to decide if this is before us. I mean,
right.
I know I'd like to hear from each board member as to your opinion, and then we'll have a vote and decide.
Chairman, the only thing I'd like to add is if for any reason the board determines that this matter should not be in front of them for jurisdictional concern, prior to that determination, I would just like to withdraw the application without prejudice so we can revisit this and not lose the opportunity ultimately to bring the application again. And we can work with the building department along those lines.
Well, I'm going to go through each of the board members and they'll give me their feeling and then you can decide what, if you want to withdraw the application or not. Okay. So who would like to start?
I will. Oh, go ahead. It's mine.
I do not believe we have jurisdiction based on the 60-day requirement.
I do not either.
I'm voting the same way.
Okay. Melissa?
I believe that we will be back here. I don't think that we have the jurisdiction right now. So I think the withdrawal is probably the best course of action.
Okay. Paul, what do you think on this?
Yeah, I haven't heard anything to make a change to what everyone's saying.
Yeah.
Way past the 60 days. I haven't heard a good reason as to why, so
Right.
I would vote that way.
Right. Arnie, what's your feel on this? I'm sorry, Arnie, you're on mute.
He agrees.
You're on mute, Arnie, still. You should be able to go to the bottom of the screen and uncheck the mute, the little microphone there, and should get you out of mute.
You hear me now?
Yes, we
Yep.
can hear you now.
Okay, there we go. No, I agree that's gone past the 60 days, where we have no jurisdiction at this time, but I find it very interesting, what's going on there, you know?
And then finally, I think I concur with the other board members. I think, from a statutory basis, we don't have the option to hear this matter. Let me just say this, though. I hope both parties, you both want to get it resolved. So get it resolved, come together and come to a solution. For both sides to be spending legal fees and aggravation, it's not worth it. But I'll ask the applicant, are you looking to withdraw your application at this time?
At this point, I believe we need to, provided that it's without prejudice, and we'll consult with the building department for a determination on how to move forward.
Okay.
Okay, we'll consider the application withdrawn at this point in time.
Thank you for your
Board members.
consideration.
Okay, all right. Thank you, everyone.
Good night.
Good luck to working it out.
Yeah,
Right.
thank you. Okay, last item then we have on the agenda this evening is the approval of the May 17th, 2022 meeting minutes. Has everyone had a chance to review those minutes?
Yes.
Yeah.
Yes.
Okay. Any changes or objections?
No.
No? Okay, I'm gonna approve by consensus. All in favor?
Aye.
Anyone opposed? Any abstentions? Okay, so we'll consider the meeting minutes for May 17th, 2022 to be approved. I will make mention that our next meeting is July 19th, 2022, which is the third Tuesday as usual in July. So that will be our next meeting. And we will not be having a meeting in August, consistent with prior years. There's a lot of vacations and things like that. So we will not be having an August meeting. I'll just make mention of that now. So any further discussion the board wants to have before we?
I just want to mention one thing, Vic, as we discussed earlier today. So starting in July, we are going to meet hybrid. Instead of all virtual, giving you the option. If you want to go to the townhouse and be present for the meeting, you can be. If you want to stay home or you want to be on a vacation in St. Martin and tune in, you can. So we have the option because only the town board, the planning board, and the zoning board have that option because we are taped. All the other boards do not have that option to be hybrids. So choice is yours. You could be there next month, skip August, go, be virtual in September, but until further notice, that is how we're going to handle the meetings.
Thank you.
Okay.
Thank you.
Thank you.
You're very welcome.
That's great.
And we do have a packed schedule for July. Sorry.
And
Which
now
will
we
probably-
just added an item, probably.
Vic,
Oh,
you're
I
on
don't
mute
think-
again.
I don't think they'll be back in July.
Maybe. We'll see.
Well, the
I don't think
deadline's
they have time
passed.
to get their
Oh,
materials
Yeah,
together.
won't be
The
back in-
deadline was last Friday, and I'm holding to it.
See them in September.
So there's no meeting next month?
Yes,
there's a
there's a
meeting
meeting
next
in
month.
July. It's gonna be
Okay.
hybrid, but there's
Okay.
no meeting in August.
Correct, I understand. I was just curious whether or not there was any applications for next month.
No.
Oh, yeah, I've got quite a few.
Okay.
All right,
All right.
oh, Vic, you're muted, Vic.
Thank you. Okay, so anything further? Anybody?
Nope.
Yeah.
Other issues we have to discuss?
I have
No,
one-
Denise, do you want us to hold on to the last application materials?
Oh, yes, please. Well, no, they're withdrawing the application.
Going to start a new
If it-
application.
If it's withdrawn, it's not
Going to be different.
it's not applicable anymore, so
There you
feel
go.
free to chuck it.
Except,
I
is
got-
it really gonna be different, is the
Well,
question.
we'll see.
We'll see.
All right, I do have a question. Can everyone hear me? Am I on mute
Yep.
again?
No, we can
No,
hear
we
you.
hear you.
Okay, now I will say that in the past meetings for the past year, okay, I don't know if anybody has been past some of these applications. I feel we should be a little bit more doing site walks. Okay, I will say that two of these applications in the past have been presented to us, and not where they're putting it in a real hardship way, but I think the board would have a different outcome on some of these applications. So keep that in mind, you know, in the sense of bringing up a question of doing a site walk.
Well, let me say this. I mean, any member that, thinks it's a good idea to do a site walk, we can certainly hold an application over to the next meeting and, put an eye on the property and take a look at it if we feel it's necessary. So that's something I certainly welcome. So,
I do have to get permission from the owners of the property. And in addition to that, generally what we do is set up like a span because no less than only 3 of you at a time could be there. If 4 of you at a time, you have a quorum and it's considered a meeting. So, and yeah, I mean, we've done that before where we've done, heard the application, postponed it, carried it over till a site walk was done. But yeah, if you feel like that's necessary, absolutely bring that up.
Well, this last one that we just discussed, I mean, I would benefit myself if I saw that situation, because one attorney is describing a catastrophe and the other attorney is describing placid existence. It can't be either one of those, really.
No,
I'd like to see it for myself.
No, I agree.
right. Okay, so that's always an open option and sometimes it's a very good idea. So we, by all means, if anyone thinks it's necessary, that's what we'll do. Okay,
Okay.
anything further?
Tom, did you want to talk? Tom Tuma?
Nope.
All right, your
Thank you.
box
Hardest guy in the
lit
call.
up, your box lit up yellow. Maybe you're talking to yourself and you don't want us to hear it.
Tom was
Often do that.
I know, I work for you.
Tom,
Denise,
sorry.
sorry.
No, go ahead.
Yes,
I was just gonna ask if that last application does come back on for, say, September, is it possible for you to get permission for site visits before the meeting? So we're not then just coming to the meeting saying we want a site visit and pushing it to October?
Good question.
Probably not right now because we don't
Yeah.
even have any case
yeah, I
right now.
think you have to.
No, I'm
He's
saying
withdrawn
if
the
it comes
case.
back.
So if they
Like,
file it,
say
right?
they refile and
Oh.
you get it in August and it's gonna be on our September agenda, can you proactively have us do a site visit before the September meeting?
There you go.
So, I mean, is that proper protocol to do it before you hear anything? And the other thing, I'm gonna have to get permission from both property owners.
Right.
Right,
You know,
but I mean,
so-
other we're gonna show up in
Yeah,
September
I
and say we
mean,
wanna do a site
that
visit.
makes a lot of sense to me. Is there, you know, I mean, Vic, do you see a problem with that? I certainly can make you all well aware of the fact that it's coming back, and I know the Woos will not have an issue having you on their property.
Yeah, I mean, if the board all decides now that we'd like to have a site visit,
Yep.
if this comes before us, I would say yes. But yeah, without an application before us, I don't think we could decide on a site visit ahead of time. But in this
Right.
instance, this seems like it's an intricate type of a matter, and maybe a site visit would be warranted. You know,
Yeah.
especially if they're in agreement and a variance is needed, we got to really, understand what the whole situation is, what kind of screening, what's the, what the engineering department says. So it would have to be a very, detailed.
Right, and just even to see like the proximity of the pool, and the setback, and how far the distance is to the other neighbor's house from where the screening is going to be. would
And
all
apparently,
come into play.
apparently the Woos have already built a fence on their property. So, I mean, they got a lot of problems that we haven't even touched on yet.
Not only is the fence on their property, but evidently the mechanics for the pool heater and the pool heater
Right.
and the pool. Anyway,
There's a lot to resolve.
I would recommend getting, consult from both property owners. I've never heard of a site visit before public hearings open, but I would suggest getting consent from both property owners for a site visit. That's just my input on that.
Sounds like a good idea.
yeah, we certainly could do that. I mean, once we get the application, I
Right.
think you're all in agreement that you would like to do that before they come before the board.
Yes.
And I will speak
And-
to,
Yeah, written consent as
yep,
well.
yep.
Assuming it comes back before us. I assume it will, but who knows?
Right, it seems like it likely will.
Right.
Well, they
So
have no CO for their pool
All right.
and can't get one until this is resolved.
And I assume they don't want to rip it out. So,
Denise, I was having a tough time hearing our attorney during executive session, just because I was in the town hall. And I just didn't understand something. And Tommy, is what he said, is that your interpretation, that if it's because I thought you said before that if it's a commercial vehicle with a commercial tag, then that's outside of the zoning. But he said you're going to individually determine whether it's a commercial vehicle regardless of its tag. Is
Well,
that
there's
right?
There's different situations, as was discussed. Is it being used for a commercial purpose? Each case is it's got to be decided upon on a case-by-case basis with all the with all pertinent information provided.
So the same truck in one house could be commercial and not commercial in the house next door.
Absolutely. I have a truck that doesn't have commercial plates, but it's a commercial vehicle.
How is it a commercial vehicle then?
It has to be commercial registered though.
No,
That's
it isn't.
Referring to.
If we're only going to use the registration to determine commerciality, I think that's wrong. Because some vehicles are clearly commercial.
I just
think
don't
what
know
it
how.
comes down
I
to
don't
is
understand that.
it's my initial interpretation of the code. I could be appealed either way, either by the person, a complainant, a complaintiff, or a person, that's being cited. So it hasn't. It's been working all these years. It's really not a very clear. I'd like to see the code clarified. It's not an easy position to be in a lot of times, and it's just a case by case basis. That's all I could say.
Well, it sounds like if somebody complains, then you would go out there and,
Right.
and go from there. But that seems very discretionary.
It is.
You
Yeah,
don't
that's what I
drive
didn't
around
understand. It's
looking
not
for
supposed
it.
to be. Sorry?
No time for that.
Yeah, I mean, we basically, as the zoning department secretary, Tommy's the zoning officer. It's just him and I in the zoning department. If somebody calls and complains, we deal with it. If, we
And
don't,
if there's something blatant, and we deal with it as well.
exactly.
It could be self-observed. It's things play out in different fashions.
We have
Okay.
a problem right now with somebody who runs a very well-known business, and he's not even running it off his property. He's running it off the abutting property.
And that's
is
the
it-
town property.
And it happens to belong to the town.
That's
And
right.
who would know
And
if the
who would
neighbor
know?
didn't complain and send me aerials?
There you go.
There's a lot
It's,
of legal aspects in considering what you can do and what you can't do.
Yeah,
And it's all on me initially.
I could write a book, right, Tom? And I often say if it wasn't
After you
for
retire, Denise, after you
Tommy-
retire.
Tommy still has building inspector in his pocket, but if people didn't complain and this board, I wouldn't have a job. But yeah, I mean, that truck on Crestway was just parked.
Yeah,
But we have people that, their employees are coming to their property, parking their cars and pulling their commercial trucks, plural, not more than 2 even, off their property. And then how do you prove that?
You get into different aspects of the code. Are you running a business? Are you working on your own house? There's a lot. Each case is an individual.
Yeah, it's not black and white.
That's why they have us.
Yeah,
Well, yeah.
right.
But I like to think I can read and comprehend fairly well. And so if I can't tell, and I have the town attorney just basically saying, well, if it's not there, then it's illegal, which doesn't make sense for me. It's a struggle. This is a particular one because I happen to drive a truck which has commercial plates, but I don't make my living with the truck. I just happen to drive a bigger truck. And I always want to be obeying the law. But if I don't understand it, and I've got a couple of advanced degrees and I do zoning work, I don't know how a regular person's going to understand it.
It's not an easy task. And if someone wants to recommend some language changes to the code, I'd be willing to work with them on that.
Yeah, this is where our recourse is to go to make some recommendations to town board and for them to decide if they want to change the code. Yeah.
Okay, I just wanted to make sure I understood the interpretation because I was having trouble hearing and it felt like our attorney was being aggressive with me. I didn't.
He was.
He was.
He was.
There was an
Sorry, I
issue.
missed that.
There was an issue with the reading of the code. I would say maybe 20 years, 18, 20 years ago, the town board adopted some language to clarify it with putting in a section that speaks to a commercial vehicle weighing 10,500 pounds, I believe it is. In an effort to clarify it, in my opinion, it really did nothing more than confuse it more. But my opinion is that the code could be more clear.
Yeah.
Okay. Yeah, I mean, thank you. I just didn't, like the Crestway case, I drive by that house every day and I see the trucks every day and I don't know. They're not working there. There's no driver, there's no workers coming there. Doesn't seem like commercial use, but they have commercial plates and so I don't know.
You ought to file a complaint.
Cops were there yesterday.
You ought to file a complaint with the zoning board.
Well, I know that the neighbor flat out told me, she said, she called me and Tommy useless and said, we're I'm not calling you guys anymore. It's okay.
Well, that's good.
Yeah. And the code enforcement officer, all three of us were useless.
We
Okay.
we
Yeah,
are
we
still,
can
we
go
are still
first.
live. We are still
Good night.
live here, right, guys?
Still on a day's work. Denise.
Yeah.
All right.
Good point, Tom.
All right.
Okay.
So if there's nothing further, we'll wrap up the meeting. Anybody have anything further to say? Any other issues?
Nope.
Nope.
No, I'm good.
All right, so we're going to conclude the meeting then. Good night, everyone. As I said, our meeting next month is July 19th, 2022, third
Right on.
Tuesday of the month. All right.
See you then.
We'll see
Thank you.
then.
Have a good night, all.
Take
Good
care.
night.
Night, everybody.
Bye-bye.